Joining us now is Jenna Ellis, a constitutional law attorney and a senior legal advisor to the Trump 2020 campaign. Jenna, over the past couple days, we've heard this debate about whether or not the president can impose a nationwide lockdown order. Of course, we've seen states take that measure, but then we've seen some of the president's critics saying that it should come from the federal level. But then critics of that decision saying that that would not be constitutional. So where do you stand on this issue?
Yeah, well, the president's been very clear, Alex, that he is cherishes the Constitution and he understands that the federal government's role here is to provide support, resources, and recommendations only to the states. And so, per our Constitution, of course, the president's critics, most of them, of course, being liberal and Democrat, want to see a more centralized federal government. They're for globalism, they're for all of the things and the propositions that the Constitution doesn't stand for. So, a national lockdown order, in my opinion, would not be constitutional. That's why the president hasn't done it. And this is up to the state and local leadership. And so, as the governors and the mayors of cities and the state level leadership look at the recommendations from the federal CDC guidelines and the task force, they have to implement them, of course, according to their own state constitutions and keeping in mind the rights that are preserved and protected by the federal Constitution as well.
And so I have another question to kind of follow up on that, because the executive, of course, has the power to regulate interstate travel and commerce. So if we take Florida as an example, a state that didn't initially have lockdown orders, but they had a lot of people coming from New York at the time. That was a concern that Governor Ron DeSantis was voicing. Does the president have the opportunity, or at least the power, to regulate travel between those two states? Or once again, is that something that Ron DeSantis would have to take action on?
Right. So that's an interesting question. And of course, the Commerce Clause has been just overextended and overbroad, broadened from the original intent. So the original intent of the Constitution simply concerned packing and shipping. It didn't concern the freedom of travel. And so while the president, of course, has even indicated that he's looked at some measures that the federal government can take, that is a state issue. And for the states, I think, to look at checks and border control measures in terms of saying if you're from a particular state, you're crossing the border, we want to make sure that you either self quarantine for 14 days. We want to have you take a fever check, some of those types of checkpoint stops. That's likely permissible, but actually simply closing state borders probably is not.
And the right to movement is an enumerated right in the Constitution, so I'm assuming that there would be a higher degree of scrutiny when it comes to that, the same way that there would be if there was a limitation on the right to assembly or freedom of speech, which kind of brings me to my next point. You wrote an op-ed recently that said states do not have the constitutional power to close down certain churches. We've seen that in a number of states so far. In fact, some even with even more harsh type of actions. I believe it was Governor Cuomo, who said that there could be punitive type of measures for many of these churches if that were to be the case, if they were to continue holding masses. So can you speak a little bit about that issue as well?
Yeah, absolutely. And I would encourage everyone to read the full op-ed in the Federalist to really understand this particular issue. And we're seeing that so many people are interested in civics and actually understanding our Constitution as applied to our rights and liberties, because we know that our fundamental rights aren't absolute, but also that the government on the state and federal level are limited in their power and authority. So when we have an instance like a church closure or like these stay-at-home orders, what's the analysis? The constitutional analysis when dealing with a fundamentally protected right, like free exercise of religion, the right to assembly, all of those things that are being impacted, the constitutional analysis provides that a compelling state interest, which we have here, the right to, or the power of the government to make sure that to protect the public health, safety, and welfare, that is a compelling interest, but the state has to advance that interest by a narrowly tailored rule and the least restrictive means. So here, the question has become for states this determination between essential versus non-essential services. That's actually the improper question. It's not for a state to determine that churches are non-essential, but grocery stores are essential. It's for the states to implement these regulations with a uniform rule. So if a state is saying, well, your business, a grocery store, that's essential, so you can implement these recommendations, these social distancing restrictions, and that's fine. And we trust that Safeways, Walmarts, and grocery stores can do that. But churches don't have the same opportunity to comply. They just simply have to shut down. That isn't constitutional. What would be constitutional is for these governors in these states to implement a uniform rule like they have in other instances, like fire safety codes, like food service rules, food health and safety rules, all of those types of uniform standards. If a business or a nonprofit or a church, regardless of service, can comply with those regulations, then they should have the opportunity to remain open. You can't specifically target one type of service over another.
So a lot of conservatives would actually say, too, that this is essentially chipping away at civil liberties to some degree, a lot of the actions taken by state and local municipalities. Do you agree with that maybe right now we are kind of allowing certain action to go ahead as they are doing right now in the name really of a larger kind of public health type of issue, that we're kind of allowing it for the time being?
Yeah, and I think that this can potentially set a dangerous precedent within the states. And we have to also be very careful for some of the organizations and the religious liberty organizations challenging these state orders. We have to be very careful not to concede the threshold question of only asking for an exemption and saying, please determine that church is an essential service. We have to say, why is it up to the state government to determine and arbitrate based on their own arbitrary and capricious standard what is and isn't essential? So I think that what we're going to see here in the long term is going to be a lot of constitutional questions that's going to further define what is the limited power of government in an emergency and what is the fundamental right and liberty that we cherish because of our U.S. Constitution. And I'm so thankful that President Trump is making sure to limit the power of the federal government, and the states have to make sure that they are obliging that as well.
And we already see this debate taking place in some states. I mean, Wisconsin, just over the past couple days, they had the governor kind of going against the state legislature, going against the courts. And we saw the same thing in Ohio, where the governor went against what the court ruled. So we're seeing this play out on a state level, and it's interesting to see it play out at the federal level as well. We should learn more over the couple days as they kind of move forward with their next plan of action. But Jenna Ellis, I really appreciate you coming on tonight. Thank you.